Good afternoon. District Court Equal Opportunities Amendment Rules 2014. So we've got a quorum and I'll call the meeting to order. Let's first of all elect a chairman, Mr. Dennis Kwok. I nominate Mr. James Toh. Are you willing to accept the nomination? Yes. All right, so I will be the seconder. So please take over the chair. I don't think there is a need for an election because there is only one nomination.
OK， 好，各位同事，咁我哋使唔使專副主席啊？
Do we need a deputy chairman? No need, I suppose. Please invite the administration in.
OK， 得。好，秘書提我咧就
The secretary, or the clerk rather, has reminded me that on the 9th of July 2014, Mr. Dennis Kwok was invited by the Secretariat to move a motion in the LegCo sitting to extend the scrutiny period till October. But then, at the meeting held on the 9th of July, we adjourned after we had finished dealing with the Stamp Duty Amendment Bill 2013. And so Mr. Dennis Kwok didn't have an opportunity to move a motion to extend the scrutiny period. But we didn't have enough time to deal with all the items for that meeting. And so the amendment rules will commence on the 1st of November this year. And that is because the motion to extend the scrutiny period could not be moved at the LegCo meeting held on the 9th of July. So we can't amend the rules, nor can we vote down the rules. But still, we think we need to study the rules. We can still give our suggestions to the administration, and the administration can make amendments or follow up at a later stage. So now, I'll introduce the administration's team to members. We have Mr. Esmond Lee, Deputy JA, Ms. Wendy Zhang, Assistant JA, Mr. Alan Lai, Senior Government Counsel, Ms. Carmen Chan, Acting Senior Government Counsel, and Ms. Tini Ho, Senior Government Counsel. So, Mr. Lee, can you please take us through the paper? Yes, thank you, Chairman. We wish to simplify the procedures at the district court level to deal with equal opportunities cases. We've consulted the legal services profession and the stakeholders, and early this year we went to the panel and there was general support for our proposals. So we mainly seek to replace technical pleadings used in the adjudication of EO claims with more informal claim and response forms. We are of the view that this amendment will save the district court's time. May I refer members to the LegCo brief? So we are proposing to use more informal claim and response forms. And we are also proposing to simplify the procedures. And these simplified procedures are in para 14 to 21. Now the copy of the claim form will be sent to the respondent, and the respondent will be informed of the date of the first directions hearing, normally about 8 to 12 weeks from the filing of the claim form. So that will be a clear timetable for the respondent. And the respondent needs to file with the court and send to the claimant a completed response form within 28 days after receipt of a copy of the claim form and the notice from the court. And so the views of the respondents and the claimants will be known. And then within 14 days after the respondent has received a copy of the claim form, or after the claimant has received a copy of the response form, either party may send a request form to the other party to demand the provision of further particulars of the grounds to substantiate the latter's case. And there is a time limit for providing further information and particulars. And we are also proposing to simplify the procedures so that at an appropriate time, the court can strike out a claim or adjourn the yield proceedings as it sees fit if a party fails to appear at a hearing. Then para 22. The court may direct at any stage of the proceedings of an EO claim the use of formal proceeding or pleadings rather, and in fact the legal advisor has asked a question, and we've explained that in some cases the court may rule that it's more appropriate to use formal pleadings. And so this is to allow the court to have flexibility in handling complicated cases. So members' questions are welcome. Mr. Kwok. Thank you, Chairman. Chairman, the Bar Association has issued statements on the rules on 2 occasions. In October 2013, there was a statement, and I believe some of the suggestions have been accepted by the judiciary. Is that right? All of them have been accepted, and they have been incorporated in the rules, and the Bar Association has raised no objection. The Bar Association also issued a statement in 2011. So is it that most of the Bar's suggestions have been accepted? Chairman, in 2011, the Judiciary Administration carried out a comprehensive consultation exercise. When we did the comprehensive consultation exercise, we gave responses to all organizations which wrote to us, including the Bar Association, of course. In fact, the Bar Association has given us very valuable views. And before we went to the AJLS panel, we had already incorporated the Bar Association's comments and suggestions in the rules. Chairman, under what circumstances will the district court decide to use technical or to adopt technical pleadings, and under what circumstances will informal claim and response forms be allowed? Is it for the judge to exercise his discretion? Chairman, the judge makes a judicial decision based on the circumstances of the case. So we can't define the circumstances under which technical pleadings or informal forms will be used. Concerning the rules, can I know the exact wording? So on what basis does the judge make a decision? Is it that he can exercise absolute discretion, or is it that he needs to consider all the circumstances of the case, or is it sufficient if he thinks fit? I want to refer to the marked up copy, page 24. It says the rules and also the directions to be made. So in other words, everything is in the words may direct. Correct. So unless we've got some common law cases, or unless we've got instructions from the Court of Appeal, otherwise the judge may direct that informal forms be used. At what stage does the judge make the direction? Is it after the claim form has been received? Or is it that he can direct only after the response form has been received? Yes, Chairman. Now, first of all, a claim form has to be submitted, Chairman. And the respondent has to fill in a response form. And then there will be the first directions hearing. And a lot of things will be discussed. One of them being whether the judge or either party thinks that technical pleadings should be used. So concerning page 2, 4, bracket 3, I mean the marked up copy, the court may direct. Alright, so it means that the court may direct only after the two forms have been received. Is that right? It seems that's not the case. In fact, 4.3 merely says that the judge may direct that technical pleadings be used. But then, these rules have to be read in conjunction with the district court rules. So we will have the first directions hearing only after the two forms have been submitted. So after the claim form and the response form have been received, then the court may direct that any provision of the district court rules made under Section 72 of the ordinance applies to and in relation to annexion blah blah blah. Is that right? So the two forms have been received, and then the court may decide to direct. Is that right?
Yes, under general circumstances, after the first directions hearing, the court will make a decision. Mr. Albert Ho. So whenever is an EO claim, the plaintiff or the claimant would have to fill in this form. He cannot use a traditional pleading, right? So first of all, he has to fill in the claim form, and then the judge will make a decision. So it's like a case management, and then the judge will decide what will be the next step. So this is an added step. You have changed the traditional way of doing it, but of course he can revert back to tradition. Our goal is to speed up the processing of claims. So for this new system, it will help to expedite the whole process. Of course, our members just ask this question, that is, at which point the judge will make a decision to revert to traditional pleadings. And that is after the first directions hearing. He would have received the forms from both parties, and the two parties may have some views. He would have to look at these views as well. As for the marked up copy, page 2, under Rule 4.3, it gives the judge the power to go back to the original arrangement. Otherwise, he may not be able to use technical pleadings. So we have to read all the relevant legislations. We understand that at the beginning, you cannot use the traditional form, but the judge can decide to do so. And for the hearing, because it involves EO ordinances, and also it's a mixed claim, so it involves discrimination and negligence. So can the claimant start with the traditional method, that is using technical pleading? Now for the EO statutes, we are talking about the 4 anti-discrimination ordinances. So you have to incur one of the ordinances and you make a claim. And if the claimant wants to make other claim under the common law, for example, under this case number, he wants to make other claims, and for the number should be DCO if it's a EO claim. So it's mainly about claims concerning the 4 ordinances. Ms. Ho, the question is like this. You have to understand the question first. Now, does the law stipulate that if it's only an EO claim, then the claim and response form will be used? If it's a mixed case, then would you use a technical pleading or a claim and response form, or you cannot mix different claims? And for the other claim, you have to pay another fee and go through another channel. This is something very technical. So the question is whether cases can be mixed. Yes, if the claims are mixed, then can he use the claim and response forms, or can he just use the technical bleeding? I think this is a very difficult question. You may not be able to answer it right now, and you can give me an answer afterwards. Please do not evade the question, because if you evade a question, I will know. Yes, I think after the meeting, we'll look into this. Yes, I know this is really difficult. We haven't anticipated this. But scenarios like this do exist. In some cases, it may involve discrimination and other things. I can cite an example. For example, in a school, there is a case. A student is bullied by another student or by a teacher, and the student is injured and he has to go see a doctor. And this may involve disability discrimination. But what are we prosecuting? We may prosecute the school for negligence, and there may also be some legal liabilities involved. Okay, let's just talk about negligence. This is quite commonly seen. So this involves DDO and negligence. So if the school has done things adequately, then this case would not have occurred. So this would actually happen. So you better go back and think about it. Well, in order not to hold a few more meetings, let us discuss thoroughly now. Now, on the 1st of November, this rule will commence because now the scrutiny period cannot be extended, so this will happen. So if we have a plaintiff and there is a mixed claim, it involves an EO claim and it also involves another claim. So can he choose between technical bleeding and a claim and response form? If he has to use technical pleading, then imagine this scenario. The defendant may think that you are making up a mixed claim so as to drag the defendant into the traditional channel, and it means more time and money for the defendant. So when the judge makes a direction in the future, can he cut the case up into two cases, or can all the claims be handled by claim and response forms? Well, if some people really want to make things difficult for the defendants, and he can drag the defendants back to the traditional method. So please think about the relevant scenarios. Any other questions? Legal advisor, are you satisfied with the answers? I'm not forcing you. So with regard to Mr. Albert Ho's question, can you share with us your views, legal advisor? If we look at 73B and 73E, these are the enabling provisions giving power to the District Court Rules Committee. And it states that the District Court Rules Committee can set up rules so that the jurisdictions can be decided. So if it's outside the jurisdiction, then the rules cannot apply. As for the old rules, if you look at Rule 5, it's about EO claims and labor disputes and the relationship between them. It says that if it's beyond the jurisdiction of the court under any relevant ordinance and within the jurisdiction of the tribunal, then the court shall order that the claim be transferred to the tribunal. But it hasn't mentioned other claims, for example, negligence. But here is a rule about labor dispute, because many of the claims are about employment ordinance. So that's why we have this particular rule. Now, if you look at the rules, some scenarios cannot be handled because some of the claims may be beyond the jurisdiction. Now, if in the plaintiff lodges a claim that is a mixed claim, then of course he would use the traditional method, that is technical pleadings. Now, can the defendant ask the judge to give a direction so that the claims can be divided into two, and one would be using traditional pleading and the other will be using claim and response forms? I have to look at the relevant provisions before I can answer these questions. Yes, I think Mr. Albert Ho has asked a very complicated question. Mr. Ho? Now we have this new set of special rules. Of course, these new rules would resolve most of the problems. However, there may be exceptional scenarios and then there may be problems. For example, labor tribunal. It is quite rare that a deceased employer will be sued. But lately, I've seen such a case, and people do not know what to do. Should there be a representative representing the deceased employer? And eventually, the case is referred to the district court. Now, if we look at it under this rule, so the person that discriminates against the claimant as deceased, so what will happen? Because, well, if you do not use the traditional channels, then if there are special scenarios, you may not be able to handle them. Yes, that may be the case. Just now you talked about the EO statutes. Yeah, that is, if the defendant has died, what will happen? Maybe Mr. Lee would have to go back and think about it. Now, because Mr. Lee is the Deputy Judiciary Administrator, I think he really should go back and study all these scenarios. Well, because for that case, the judge asked me to write a lot of submissions, and eventually he decided that the case should be referred to the district court. So the judge of the tribunal didn't know what to do. So you really have to look into this, because I have seen this case and the labor tribunal really didn't know how to handle it. Oh, for 4(2), it states that the provisions of the rules of the district court made under Section 7(2) of the ordinance apply with any necessary modifications to in relation to an action or proceeding falling within the jurisdiction to the extent of any matter for which no provision is made by Part 2. And if there are mixed claims, then the court may have separate trials. So there are two causes of actions. This is one way of handling it. But that would be the final stage. And if it's very complicated, then maybe the case will be divided into two proceedings. Because when it comes to a trial, it's already at a late stage. So I think Mr. Lee knows what we are concerned about. Our legal advisor has found something about trials.
Chairman, I think there must be clear instructions because we have to file in a form. But I understand that the office will have to seek the instructions of the judge or the registrar. Now, of course, you can't be denied the right to file a form. I wish to follow up, Chairman. Now, the judge can exercise discretion, but then it seems that the factors that he has to consider in exercising his discretion are not listed. For example, the legal costs, whether the case is a complicated one, or whether it's in the interest of justice to do so. So these factors are not listed in the legislation, but we believe that the judge will make the best arrangements to ensure that justice can be done. But we don't even have the general principles. Now, the lawyers on both sides may agree that the case is simple, but then important principles are involved. Now, either the principles are laid down in the legislation, or the court or the judge will interpret the words made direct. And if a wrong decision is made, that decision is subject to appeal. But I believe few people will use their cases as test cases. But then can the judiciary tell outsiders what factors the judge is likely to consider? The legal costs, whether the case is a complicated one, whether the two parties are legally represented, and so on and so forth. I believe the court will take into account a list of factors. Is that right? Chairman. Because we're dealing with various steps, and the judge can exercise his discretion to order that technical pleadings be used. Now, we have come up with some simplified procedures because the judge is inclined to adopt informal procedures unless the case is complicated. So the judge will revert to the previous mode only if there are special circumstances. And so it will be rather difficult to really list such scenarios. But of course, the judge will have the benefit of the views of both parties, and the judge will come to a decision that will make sure that justice can be done. All right, to err on a safe side, let's do a clause-by-clause study. All right, let's deal with the English version. So this is paper 967. The marked up copy, page 1. Mr. Lee, please. All right, first of all, the interpretation, the definition of district court. We have the definition in Order 1, Rule 4, Bracket 2. This is for consistency's sake. And then in the marked up copy, we have new definitions. This is because we have different forms in the notices. I think this is not a very serious matter. But here you have forms 1, 2, 3, and 4. And in the printed forms, will you also specify the nature of the forms? Say, for example, this is a claim form, this is a response form, and so on and so forth. In fact, we do have such information later in the marked up copy. But your definitions relate to Form 1, Form 2, Form 3, and Form 4. Yes, all right. Let's move on to page 2. Application. We've substituted the term the Crown with the government. And then 4, application of other rules. So the court has the judge has the discretion to order that technical pleadings be used. All right, replacing the Crown with the government. This is an adaptation exercise, right? You're taking advantage of this exercise to do the adaptation. Now, the government, of course, includes the SAR government. What about state organs in Hong Kong? Will they be covered? This is a matter of interpretation of the law. The judiciary will not give any comments. I think the administration will be in a better position to answer this question on interpretation. Now, here we are only talking about the forms, and if the yields equal opportunities legislation doesn't apply to the state organs in Hong Kong, then no claims can be made against these state organs. I haven't really done my homework. I don't know whether the 4 pieces of anti-discrimination legislation apply to state organs in Hong Kong. Perhaps I can ask the legal advisor to do some research. Let's move on. 4. Also, the judge may still order that technical pleadings be used. Now, in fact, the rules will come into effect on the 1st of November, so we can't amend the rules. But if you have got some suggestions, do raise them, and the administration may consider your suggestion in the future. So, Mr. Ho, do you want to put your suggestion on record? I've already stated my suggestion, and I have nothing further to add. Page 3. Sorry, Mr. Lee. I'm just a bit worried that this may happen. Now, if the anti-discrimination legislation applies to the state organs in Hong Kong, then what I mean is this. assuming that people can sue the SAR government, right, under the anti-discrimination legislation. But if the legislation states that, in fact, state organs in Hong Kong can also be sued, and yet in the rules before us, we only have proceedings against the government, not state organs in Hong Kong. As a result, people can't make any claims against state organs in Hong Kong. Yes, Mr. Lai? Mr. Lai? Did you raise your hand? We've studied the 4 pieces of anti-discrimination legislation, and they only apply to the SAR government. Oh, all right. Page 3. Page 3. Part 2. Section 7 is about making claims. Then let's move on to page 4. So Form 2 to notify the respondent, and then page 5. The respondent can make a request for further particulars, and he has to use Form 4. Page 6. After the respondent has received Form 1, then a response has to be made using Form 3. Then Section 11, the claimant can seek further information using Form 4. Then page 7, Division 2. Section 12, interested parties may be joined. Then Section 13, default of response. Then Section 14, default of appearance. Then Section 15, discontinuance and withdrawal. There are these procedures. Then Section 16, name and address to be provided. Then Section 17, change of address for service. Section 18, manner of service. So all these are laid down. Then Section 19, time at which service by ordinary post is effected. And then 20, substituted service. 21, amendment of documents. 22, failure to comply with this part, the consequences. Then 23, the 4 forms. And for each form, we do explain the purpose of the form. All right, let's look at 7.
咁於是咧就去到咧就係3嗰度 B， 咁就
Then 3B, the person's name and address.
in whom the claim is made 啦，係咪？
係。
OK， 即係俾人告嗰個啦。好啦，一跳到第8咧。
And then 8, all of a sudden, there is this word or term respondent.
The court is to cause to be served on the respondent。
係。
咁其實呢個 respondent 一定係指3C 裏邊嘅人啦。
係。
The respondent means the person mentioned in 3C, right? Yes. So, maybe under 3C, after against whom the claim is made, you should write respondent. Chairman, in fact, on page 0001, the definition of respondent, we've already, which one? Definition of respondent means the person against which blah blah blah.
Okay.
So it's in, right at the beginning, yes. Because I didn't refer back to page 1.
Okay, claimant 就係
And claimant is 7.1. And respondent is 3C. 7.3C. So you've put down 7. Okay, and now I understand. And members, do you have any other questions, Mr. Ho? Can we look at 4 again? Application of other rules. That is on page 2. (4) 3. You explained to us just now, Mr. Lee, that the claim and response forms will be applicable first until the court directs otherwise. But under 4.3, it doesn't seem like what you stated just now. It says that the court may direct. It seems that the court has to direct first. Now, if you look at 4.3, it says the court may direct blah, 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 as if Part 2 had not been enacted. Part 2 is new. So if you do not invoke 4.3, then you will have to follow the new system until the court directs that as if Part 2 has not been enacted. So you would use technical pleading. So it's like what I said just now, you would use the new form unless the court directs that the old form be used. So this is what 4.3 aims at. So for the new form, in the very beginning, you would have to use it. So under which rule do we see this? Now, after passing these amendment rules, then from Part 2 onwards, that is from page 3 onwards, until the end of the amendments, then this will become part of the rules. Then they will have to follow the new rules. Unless the court wants to use the old pleading system, then the court can invoke 4.3 and do so. So for Part 2, it's mainly about pleadings, right? So other than this part, other than pleadings, would it be applicable to other areas? Other than pleadings, we also mentioned the service of documents and the amendment of documents. Well, they are mainly about pleadings, but also they are also about procedures in a later stage. Because for district courts, the procedures are really long and complicated. So this is just a small part. So for the remaining steps, we will still adhere to the district court rules. So for those that have not been replaced by Part 2, then the district court rules still apply. So in the beginning, the court can also say that the new forms will not be used and it will stick to the traditional pleading. Yes, because we want to make use of different ways so as to handle the cases as rapidly as possible. I would like to ask a question about Rule 12.3. This rule is about interested parties may be joined. It says under Bracket 3 that unless the court gives leave to the contrary, the copy of that notice must be served not less than 2 clear days before the hearing of date set out in that notice. How come the period is so short? at least you should give them a few more days, right? Because it's the hearing already. Well, for this provision, we have made a reference to 2 other similar provisions concerning less formal cases. One is about employee compensation, and that's under 2A2B, and the other is land tribunal, and that's under 17A. So for 2 clear days, they already exist in some other legislations, and we would think this period is enough. So now we understand the scheme. So you start first, and then the court will look at it. Now, just now I mentioned some other scenarios. Now, because Part 2 may not be comprehensive, there may be scenarios that are not covered. For example, the defendant has died already, or the defendant is a minor, or is mentally incapacitated. So can we invoke Part 2? So please think about all these scenarios. So we're talking about a minor, or the defendant has become mentally incapacitated. What will happen? Oh, this is really difficult. But we really have to look at these exceptional scenarios. We can always see joinder. That is, that interested parties may be joined. Now, if you handle other cases, would it take more time? Well, you can imagine this. Now, if I receive a form and I'm giving 2 days, and if I do not appear in court, then I will get into a lot of trouble. Maybe I want the judge to give me more time, but I may not be able to appear in court because you just give me 2 days notification. Of course, I understand that this cannot be changed now, but I would like to let you know my view. So for joinder cases, can you give people a few more days as a norm? Because before that party has not joined yet. So the plaintiff and the respondent are making their own statements, and the judge would have to make a wise decision as to whether 2 extra days will be given. Now, because the person that joins later is an ex-parte, so he had no say before. If no special leave is given, then he would just have 2 days. So for this norm, I think it should be lengthened. I don't know why you have to drag him in so fast, and why you think 2 days are enough. So this is my view. And now the scrutiny period has ended, and we cannot amend it. And even though you take this into consideration, you will not amend it in the near future. But this is still my view. So for other legislations, if there are similar scenarios, maybe you should consider providing a longer period. For example, 5 days, because the party has not joined yet. Well, we have discussed this. According to our operational experience, if that person thinks that 2 days are really too short, and if he really cannot appear in court on that day, then he will tell the judge, and the judge will follow up accordingly. So how does he do that? He writes a letter, or he makes a phone call? Well, they haven't told me such details. However, when they hear the views, then they can make a direction. But you can imagine, you just give people 2 days. For an ordinary person, he will think that the court summons him. And of course, he will try his best to appear in court. He may take a days off in order to do that. If he has enough knowledge, or if he has legal advice, of course, he will know what to do. However, you shouldn't rely on this, thinking that definitely he can inform the court. But if he does not appear in court, then it will be a big problem. Now, for example, if that person or that party that joins is living in an elderly home, maybe he's not that capable of doing that. So it's a third party. And can he ask a next of kin to appear in court on his behalf? So a lot of things has to be arranged. So I think you should consider giving him a longer period, because this is not that urgent. So members, do you have any other questions? If not, let's go on to page 13. Mr. Lee, where did we end just now? Was for the forms, I've explained about them. So do you take reference from any other documents when you put together the forms? We have made reference to other countries' similar forms. They have also handled a lot of EO claims. We have also looked at our principal legislation, and also we have a lot of operational experiences. We know that what kind of information would be most useful. So that's why we design the forms accordingly. So for those boxes, you have to tick them, right? We have looked at the actual cases. We have also asked the stakeholders. That's how we came up with the forms. So EOC also supported the design of these forms, right? Yes, we have also consulted EOC. Is one of our stakeholders. They have approved all the forms. So there is also a claimant's language, very detailed. So members, any questions concerning the forms? If not, Chairman, for this marked up copy, we have a Rule 9, which is a transitional provision, and it is not highlighted in a marked up copy, and I would like to talk about it. If you look at the logical brief, we have mentioned some transitional provisions. That is, unless it's under certain circumstances, otherwise the old practice would be adopted. Now, before the 1st of November, if the old way is used, and after the 1st of November, people would have to use new forms. So what will happen to the old cases? If it's before the commencement dates, and the old way will be used. So you will use the whole old system, right? Yes. Also, okay, there are transitional provisions. Some members have asked some questions. And because now we cannot scrutinize the rule anymore. The government has given us some information. I will give the information to members unless members want to convene another meeting. Otherwise, we will make a report to the House Committee.
But if members still want to give you some written suggestions, those will be forwarded to you and also to the House Committee. I think the questions that were asked may be helpful to the users. So I hope that we can have the information before the rules commence operation. No problem, because the commencement date will be the 1st of November. All right, so thank you very much. Meeting adjourned.